the Smithfield Review now, volume 12, 2008, it says here, Indian Slavery and Freedom Suits, the cases of Rachel Viney and Rachel Findlay. Although we often think of Negro slaves obtaining their freedom under certain circumstances, it is also true that some Indians, what's the difference, right? In Virginia, who were slaves, obtained their freedom. Many of them used the court system in Williamsburg, especially in the 1770s when a multitude of cases were heard. All right, a multitude of cases, many cases, hundreds. The procedures were later spelled out in the Code of Virginia, and freedom suits were mentioned in the files of the Superior Court and local court orders, and in decided cases of the Supreme Court. This article tells the story of two women, residents of Southwest Virginia, who obtained their freedom through the local court systems. Rachel Viney in 1815 and Rachel Findlay in 1820. How could slaves file a lawsuit against their master? What a great question. All right, think about that. We've saying this many times, right? We know the truth. Why, right? Because they were indentured servants. How could slaves file a lawsuit against their masters, right? If it was all about Kunta Kinte slavery. They're going to admit they don't know, but they're going to suggest a reason. It says here, continuing, in these specific cases, the exact details are missing. They don't know. They don't know how. They don't want to say. They want you to think all African slaves, right? They don't want you to know about indentured servitude and contracts. But it is known that Quakers, Methodists, and some local citizens were often willing to give assistance and encouragement. Yeah, who's the Quakers and Methodists? These were black folks too. Yes, let's not forget what we've learned in the previous presentations. If the slave could reach the courthouse, then the laws of Virginia were specific. Persons who believed that they were entitled to be free were permitted to appear before the justice of the court in the country where they lived. So now it was regular things. So if you thought you were free, you could just go to court? That doesn't sound like slavery to me. If the court believed there was enough evidence to hear the case, the slave was permitted to file a petition reciting the reasons for the belief. Now slaves are filing petitions and taking their masters to court. Do you guys see what we're reading? The facts of the case usually show that the individual was descended in the maternal line from an Indian brought into Virginia and held in slavery at a time when such was illegal. Such illegal enslavements of Indians occurred repeatedly. After the case was filed, the master or owner of the slave was required to appear and post bond in an amount double the value of the petitioner. In the meantime, the slave was protected by the sheriff of the county. All court costs and attorney fees were free because the slave was usually without means and considered to be a pauper. All right, so they were even protected by the sheriff. The slaves were being protected from their masters. Does this sound like what they told you in school? I'm being real with you. You got to remember what they told you in school. It's not what they told us in school. Not in my elementary school in Boston. These freedom suits were often referred to as in forma pauperius cases. Some were indexed under the word pauper or the first name of the person bringing the suit. Seldom were surnames mentioned, but the two cases that follow are exceptions. The master's bond required that there be no interference and no abuse toward the slave while the evidence was being gathered, and there was to be no prohibition from allowing the summons to be obtained. Yet in at least one instance in Southwest Virginia, the lower court refused to hear a case. Consequently, the attorney filed a right asking to transfer the case to the higher or superior court. This fact emerged from the Findlay lawsuit, where documents filed proclaimed that because a certain relative of the master was a justice on the court, it would be impossible for the case ever to be heard there. In the two specific cases mentioned in this article, one was filed in Montgomery County and the other in Whitty County, Virginia. Each of the petitioners was named Rachel, one with the surname Viney, the other Findlay. Each had been freed by a court in Eastern Virginia, but since these records have not survived, exact details are unknown. Oh, they don't survive, huh? You burned them, you destroyed them, or you just hiding them? Even though the slaves had obtained their freedom, their masters moved them westward, where they were sold illegally as Negro slaves. Again, who? Remember, these are Indians, and they were sold as what? And illegally selling them as Negro slaves. As a result, the two Rachels had to file freedom suits to try once more to gain their freedom. They had to go to court again. You guys hear that? They already had won their freedom. Rachel Viney and 18 other members of her family were from Northumberland County, Virginia, and her first case was held in the District Court for Richmond, Westmoreland, Lancaster, and Northumberland, where they recovered their freedom by verdict dated September 7, 1791. In addition to their freedom, they were awarded 1 shilling in damages. These facts were recited in the case filed in Montgomery County on December 23, 1806, when for the second time Rachel filed for her freedom. The evidence showed that her ancestor was Mary, who had come into eastern Virginia by ship with her granddaughter Bess. They were identified as Indians, not Africans. Again, I'm going to repeat that because you didn't hear. They were identified as Indians, not Africans, and were described as being of yellow complexion and had long straight hair down to their waist. Bess was a young girl of 12 or 13. No Indian tribe was mentioned. Rachel Viney was a child of Sarah, a descendant of these 2 Indian women. The case stated that she had been sold back into slavery as a Negro. She was purchased by Henry Patton, of a well-known family who lived in that part of Montgomery County that is now Pulaski County. Her petition was filed in March 1807 without fees or costs because she was classified as a pauper. She filed for trespass, assault and battery, and false imprisonment, which was the standard request in such cases. Not only was she suing for her own freedom, but she was also petitioning the court for her children, Hannah, Santy, Jimmy, Abigail, Joe, and Solomon, all of whom were being held illegally by Henry Patton. In addition, she sued for her son Marcus, who was in the possession of Samuel Patton, a son of Henry, and her son Jupiter, who was in the possession of Andrew Johnston of Giles County. Her daughter Hannah's 3 children, Sam, Daniel, and William, were also included in the suit. After more than 8 years in the court system, all were declared to be free in 1815. In 1816, the Giles County list of free persons of color included Rachel Viney, age 49, then living in the New River at Phillips Peters Place. Her occupation was listed as spinster, meaning someone who does spinning and weaving. Also in Giles County were Hannah, age 27, Jupiter, age 22, Senty or Santy, age 18, Abbey, age 14, Joe, age 12, Solomon, age 10, Sam, age 7, Daniel, age 5, Bill, age 3, and Jim, age 4 months. In 1830, Jupiter, Jimmy, and Hannah were still residing in Giles County. The other Rachel, identified as Rachel Findlay, had a similar experience. She was declared to be free the first time in 1773 by the court in Williamsburg. She claimed her descent from her grandmother named Chance from the matrilineal line, who was brought into Virginia by Indian trader Henry Clay of what is now Powhatan County. All right, Indian trader, Indian slave trader. Based on uncertain evidence, Chance was approximately 6 years old and had been kidnapped by Clay somewhere in southern Indian nations. Catawba, Choctaw, and Creek were all mentioned. All right, but when you look at the place, I'm gonna tell you guys now, when you understand where she got kidnapped from, when we're talking about Virginia, we're most likely talking about Catawba more than Choctaw and Creek. 2 Indian children, Chance and James, who was about 8 years old, and their progeny were raised by the Clays. The exact date of their arrival in Virginia is not known, and it is not known how soon after their arrival Henry Clay took them to the Henrico Court in August 1712 to have their ages adjudged. At this time, Indian slavery was no longer legal in Virginia, a fact ignored by the Clay family. Rachel Findlay, the granddaughter of Chance, was illegally transferred about 1773 to the frontier of Virginia by Mitchell Clay of Powhatan. She was then 20 years old, and her daughter Judy was 6. They lived in the remote parts of what is now West Virginia, at the place later known as Princeton. The following year, Rachel and Judy were sold as Negro slaves to John Draper, who lived in Draper's Valley, in that part of Whitty County that became Pulaski, all right? So again, and I want you guys to really pay attention to what I'm about to say here, and especially those who are doing genealogy and get confused when they find probates and wills, and when they're saying, oh, I give you to my daughter, my Negro slave, Henrique, whatever name they have. Because as you can see here in this article, they sold Rachel and Judy as Negro slaves to John Draper. So if you would read a probate or a will that included Rachel and Judy as Negro slaves, you would never imagine. Most people would consider automatically that these are African slaves, and that's not the case. This is something very important to look out for. And don't think these are white people who are doing this and selling the people. Again, this is indentured servitude, and they were doing this to American Indians and other unwanted Europeans. They were doing it to their own people. This is what they were doing in Europe before they got here. While with the Drapers, Rachel had 11 children, and although she attempted many times to find someone to help her get to the court 20 miles away in Whitfield, or find an attorney to help her, she did not make the trip until 1813. She was then 60 years old and had 42 descendants, many or all of whom would also be entitled to their freedom if her case succeeded. Okay? The results were not immediate because her evidence had to be gathered in Powhatan County, where the elders of the community knew her and her circumstances. Court papers show that Rachel made at least 2 trips to Powhatan to take depositions for the trial. Eventually, the case was transferred to Powhatan, and in May 1820, after 7 years in the court system, she was once again declared a free person. Do you see how much she had to fight for her freedom? Twice. The second time, man, she had to fight for all these years just to prove who she was. Not only did Rachel Findlay file her case for freedom, but 30 of her 42 descendants can be identified in various lawsuits which followed, okay? So again, you got slaves going to court and suing their masters. Lawsuits. You guys understand? That slavery narrative they gave us in school is all false. Break the spell. In addition, her youngest daughter somehow found her way to Huntsville, Madison County, Alabama, and records there show that she received her freedom based on her mother's successful lawsuit. Other members of Rachel's family were probably given to Draper children who moved west and left no local information. So meaning, they probably never got freed, or they didn't find out they could be freed. They just got taken to the west without knowing what happened. The court order books mentioned those family members of Rachel who had been freed in the local courts. Their freedom was granted based on the fact that their mother or their grandmother, Rachel Findlay, had been freed by the court in Powhatan. Later, the same court recognized her success when she filed for registration as a free person of color descended from an Indian named Chance. Rachel Findlay's story appeared in the Journal of the Afro-American Historical and Genealogical Society in 2003, even though earlier, right, they admitted she wasn't African. They're not Africans, but they're being called Afro-Americans, right? They got put in this book, they got tagged, they got grouped into the Afro thing. In addition, court papers filed in Whitty and Powhatan counties were used as a basis of the historical novel Free in Chains, written by this author and published in 2002. Since publication of the novel, the article in the JAAHGS and the book Free People of Color, a descendant of Chance, who traced his heritage through Rachel's daughter Judy, her daughter Anne, and her daughter Melinda, had been identified and is residing in Florida. He has an extended family living in various places in the United States and is very proud of his Indian heritage and the fact that he was able to make the connection to Chance, born about 1706. The reader can only imagine what it must have been like for their 2 Rachels to know that they had followed the rules, gained their freedom, and then were betrayed and returned to slavery as Negroes. All right, pay attention, guys. This happened many, many times in many, many cases. You're gonna find this in the genealogy. You're gonna hit dead ends and stuff. You're gonna be weird, like, what's going on? Rachel Viney spent 24 years in illegal servitude after the first court case in Northumberland. It took the Montgomery County Court more than 8 years of that time to reach its decision. Rachel Findlay waited 47 years for her freedom after her case was heard in Williamsburg. 7 of those years were spent waiting for the courts of Whitty and Powhatan counties to act. dreams of freedom for themselves, and their many descendants must have given them patience and determination to win from real situations, real history. It was a struggle. Hope you guys enjoyed this brief presentation. Make sure to catch those Indian slavery videos I did in the past if you haven't. A lot of good information so you can understand what really happened when it talks about these slave narratives and all that. Much love and respect. Pura vida, mi gente. Wow.